Okay, this one is on land titles, and what we're going to be talking about is land now, okay? We're all products of the government's educational system. The government has taught us what we need to know to operate in their system, but have they taught us everything? There's several kinds of estates. There's absolute estate. An absolute estate is a full and complete estate, and a estate in lands not subject to be disputed upon any condition. Allodial means free, not holden of any lord or superior, owned without obligation of vassalage or fealty, the opposite of feudal. What you see nowadays is feudal, but you can have allodial. Allodium, land held absolutely in one's own right and not of any lord or superior. Land not subject to feudal duties or burdens. An estate held by absolute ownership without recognizing any superior to whom any duty is due on account thereof. Now, I just want to get some documents here. I got some land patents back here, and I just like to this one somebody's been handing around. This is an example of a land patent. These are BLM. These are back. There's only a few of them, so you got to pass them around, take a look at them. What this is, I guess I'll turn this on first. What I have here is this is one of those railroad land grants, okay? And this is a Santa Fe Pacific Railroad Company land grant. When they built the railroads, they gave the railroads 10 miles of land on either side of the railroad, and that was to pay for the railroad, okay? And this is one of those land grants. And so you ought to pass it around, take a look at it, and we're going to be talking about it. If you register your land, well, and this is in Canada, in the US, you have a counter recorder, and it's recording your land. If you register your land at land titles, you're essentially giving them your land. And in Canada, it's very much more feudal than it is here. Even the Canadian land patents are feudal. And they even know it because they put them in boxes. They know they don't have any authority. But here, it's much more proper, I guess, de jure. The land patents, it's a stronger history, actually, with land. Okay, but anyway, so let's keep going here. So in Canada, though, you need to record your land. You need to train your bureaucrats about land titles. And even with the counter recorder, or once you give them, and this is the same with land titles in Canada, once you give them a document, it's recorded, okay? And if they give it back to you, remember you had that question about that? About if they give it back to you, then that's condemning a government document. That's exactly what it is, and that's a felony, okay? But if you're going to accuse them of felonies, you better have witnesses. And so what you need to do is build a case against them so that you have witnesses and you can accuse them of a felony. Okay, because if you give them a document and they say, I'm not going to record that and give it back to you, they just committed a felony. That's condemning a government document, because once you gave it to them, it's theirs, it's recorded. Okay, and that's why I always send it to them by registered mail, because now I got proof they got it, and if they send it back, then they committed a felony, and I got proof they did that, and you know. Anyways, so you need to build a case against them. That's you know, again, it comes down to the burden's on us to build a case and get our public servants into line, right? Real property, land and everything that is attached to the land. Real estate. You notice how they call everything real estate? Words are everything, okay? Real estate is real property that you have an interest in, but you don't own it. Estate is the operative word, and estate is something you have an interest in, but you don't own, like your father's estate. Okay? You know, all of this stuff is very subtle, and unless you're really watching for it, you won't even catch it. There's land titles come in various forms. There's a general warranty deed, a special warranty deed, a sheriff's deed, a judicial deed, a quitclaim deed, and a land patent. And this is the same in Canada. A general warranty deed is one where the seller warrants the title to be free of all liens and encumbrances. A general warranty deed is generally what's received in order to get a mortgage, but before the bank will authorize the mortgage, and a general warranty deed is considered to be marketable title. Okay, there's a land terminology you should be aware of, marketable title. We're going to see some court cases about that. A special warranty deed is the deed where the seller will warrant the land to be free of all liens and encumbrances with some reservations, okay? And the reason there might be a reservation if it was subject of a foreclosure or tax sale, okay? And that clouds the title. And a special warranty deed, though, is considered to be marketable title. Sheriff's deed, the sheriff sells real property, but whenever the sheriff sells it, it's usually because of a foreclosure or tax sale or, you know, a court-ordered sale. Sheriff's deed is considered to be marketable title. A judicial deed is when a judge orders real property sold. A judicial deed is considered to be marketable title. A quitclaim deed. A quitclaim deed essentially says that the seller transfers his interest in a piece of property. Okay? Property sold because of a tax sale. I've seen property sold because of a tax sale being a quitclaim deed. A quitclaim deed can transfer title as effectively as a general warranty deed, but it also may transfer nothing. Okay? Now, have you ever heard of the Brooklyn Bridge being sold? Yeah. Okay, well, it's always by quitclaim deed. Okay, and it's actually owned by the state of New York, and so they've never sold it. But a quitclaim deed essentially says, I sell you my interest in this bridge. I may not have an interest, but whatever interest I have, I sell. Right? That's what a quitclaim deed says. Okay? So, a quitclaim deed, a deed of conveyance operating by way of release that is intended to pass any title, interest, or claim which the grantor may have in the premises. That's why with a tax sale, okay, they're selling you their interest in the property, their claim on the property. Color. Okay, now we're getting back to color, remember? Those definitions of color. An appearance, a semblance, a simulacrum is distinguished from that which is real. Colorable, that which is an appearance only, not in reality what it purports to be, hence counterfeit, feigned, having the appearance of truth. Color of law, misuse of power possessed by virtue of state law, made possible only because wrongdoer is clothed with authority of state, is action taken under color of law. Get a load of this. These deeds include the ones as follows: a warranty deed, a quitclaim deed, a sheriff's deed, a trustee deed, a judicial deed, a tax deed, a will, or any other instrument that purportedly conveys the title. Each of these documents state that it conveys the ownership to the land. Each of these, however, is actually a color of title. When we say a person has a color of title, whatever may be the meaning of the phrase, we express the idea that at least that act has been previously done by which some title, good or bad, to a parcel of land of definite extent has been conveyed to him. There the complainant seems to have relied upon the tax deed as conveying to him the fee, and to sustain such a bill it was incumbent upon him to show that all the requirements have been complied with. In other words, you know, I don't care about the fee. That's fee simple. That's in the matrix. That's immaterial to what the reason I'm bringing this out here, okay? The point is that when you buy the land, remember, a caveat emptor, right? Buyer beware. If you buy land from somebody, it's up to you to prove you have title. Okay? You need to be aware of that. You buy a land from somebody, they don't have to prove they sold you anything. You have to prove that you have title if you want that land. I mean, the guy could be involved in fraud, but that's a civil matter. You see what I'm saying? You have to prove you have title. Yes?
What kind of deed do you ask for if you want a deed that you don't want to record or to establish ownership?
We'll talk about that. Authorities hold that to render a title marketable is not only necessary that it shall be free from reasonable doubt. In other words, that a purchaser is not entitled to demand a title absolutely free from every possible suspicion. Okay, so they're saying essentially that marketable title does not necessarily mean that your title is free from all suspicions. Okay, marketable title is just reasonable doubt. Okay, it comes down to these vague words that they like using in the Matrix. A patent to land issued by the United States under authority of the law is the highest evidence of title, something upon which its holder can rely for peace and security in his possession. It is conclusive evidence of title against the United States and all the world. Okay, so, excuse me, a land patent is the highest and best title. Okay, and that is the real title. But it's like Morpheus said, I'll show you how deep this rabbit hole goes. Okay, nothing but a patent passes a perfect and consummate title. Okay, a patent issued by the government of the United States is legal and conclusive evidence of title to the land described therein. No equitable interest, however strong, to land described in such a patent can prevail at law against the patent. Now remember that guy that went and did the bill of exchange on the vehicle, right? He said he was transferring his legal and equitable title. Okay, now you have to understand, when we get into de jure government, everything's under martial law, and what happens is that the courts use their equitable powers. Okay, and what happens is that because the government's bankrupt, okay, equity, see, normally equity is supposed to follow common law. Okay, and equity is the power of the court to do what's right. Okay, and normally equity is supposed to follow common law, but under martial law there is no common law. And so then what happens is equity can do anything they want. And in fact, in Canada they actually codified it in some statutes, and they might even have done it here, where in the statutes in Canada they will say that where equity and common law conflict, equity always prevails. Okay, yeah. And so what they're saying essentially, and so then what happens when the banks want to foreclose on your house, right? Then the court will basically ignore all your arguments and give the bank and just let them do whatever they want to do, and make them so they don't have to produce the note, just let them do whatever they want to do, because the government's bankrupt, there's no common law, and equity prevails. And equity allows them to do anything they want, basically. And that's what you see going on in the courts, is that they can do literally anything they want, and it's because that everything's in bankruptcy. Anyways, so the reason I mentioned that is the issue here is no equitable interest, however strong, to land described in such a patent can prevail at law against the patent. Okay, so no equitable interest, and that's powerful. That is really powerful. Anyways, a patent is the highest evidence of title and is conclusive against the government and all claiming under junior patents or titles until it is set aside or annulled by some judicial tribunal. Issuance of a government patent granting title to land is the most accredited type of conveyance known to our law. A patent is intended to quiet title to and secure the enjoyment of the land for the patentees and their successors. Thus, as a quitclaim deed, see that? As a quitclaim deed, a land patent conveys whatever interest the government has in the soil and the land. Now, the reason that's important is, think about it. Who was here first? Who was here first? Huh? The First Nations. Exactly. So the government essentially stole the land. That's what even the Canadian courts are saying, that the government has to settle the Indian land claim.